registration to USPTO gives you a presumption of federal coverage. And so you want to do that if you can. When you can do it, as soon as you can possibly. Once you're in the business and you're out there and you're starting to develop goodwill, and if you have no real customer base yet, you haven't developed any goodwill. So maybe it's not worth spending the money for USPTO registration. But you know, it's kind of, again, a judgment call, depending on your business, your competitiveness, resources. You know, again, why are they helpful? They're an asset. People buy companies for the mark all the time. You know, not, you know, particularly if you were looking to absorb somebody. You know, like for example, you know, restaurants all the time get acquired by conglomerates, and they always operate underneath that original trademark. You know, like Panera Bread was absorbed by another company and got a good name. So of course they're going to maintain using the Panera Bread name because people know it and they know what they sell, and so it has an association. So it's a very good mark. Again, very arbitrary. Panera has nothing to do with bread or bakery or food. It's totally made up. The closest thing you can say is maybe it's suggestive because it's a play on pan, which is bread in Spanish. But that's a stretch. I mean, so that's a good name when you think about it. Transferability, not as transferable as copyrights. Copyrights you can sell like anything, but trademarks you gotta sell the business. You can't just sell the marks, because if you don't sell the business, you've destroyed the source identifying nature of trademarks, and so they generally won't let you do this. So they have to go with the company, but again, they add value. They add, if you have good value and you're known in the industry, they have value. You know, so offensive use, you can sue people. Counterfeit product protection is easier. So if you got someone making counterfeits of your stuff and they're coming off the boat in China, you can actually get customs to seize it. And this happens to clients of mine. Will seize it until the trademark owner gives them permission to release it. They think it's counterfeit. So for example, 3M makes Velcro. Everyone's familiar with Velcro, but that's a trademark for the hook and loop fastener, as they would say. You know, Velcro, it's not Velcro unless it's a 3M Velcro, but almost everyone uses it to describe the hook and loop fastener, right? So if you put Velcro on your shipment of whatever coming from China, and it's not one of the registered agents that they have given, that Customs knows is dealing with 3M, they'll seize your stuff as counterfeit. Even though it may, just the hook and loop fastener may be part of a whole other product, just a tiny piece. If someone writes Velcro, the Velcro is having to find a mine. Yeah, this is the Velcro version. You know, they seized it, and you have to wait for the giant mega corporation, 3M, to decide to give you the right to take your product. So it's a big deal. So basically, trademarks become much more important as you scale up. You scale up, trademarks become critical. When you're small, you're a startup, just pick a good name. Make sure it's not running into anybody. Make sure it's not descriptive. Register it if you can. It's not if you pick a good name, it should be relatively easy to register it. You know, and so on your end of the same, it's important to know about it and to protect your own name. But actually, probably as a startup and where you guys are going to be at, just don't run into anyone else's strong marks. Be careful. Question?
Question about the counterfeit. What if your business is operated in U.S. or just Florida, and someone in the same state or just country is counterfeiting it? Is there anything that you can do to protect yourself?
It's in the United States?
Yeah.
It would just have to be trademarked. Customs doesn't have the authority outside of it being imported. It would just be typical trademark infringement. And I don't know if there's a counterfeiting action that's for domestic. I'd have to actually look that one up. That's a good question, actually. I think it would just be standard trademark infringement.
Okay.
But basically, with trademarks, again, just kind of avoid, don't run up against. Some people are extremely aggressive, about their marks. Coca-Cola, they're notorious. Apple, very notorious. Disney, they will. These are folks that they have teams of lawyers. They monitor they do crawls on the internet. They're really looking for this type of stuff. So it's just easier to stay away from it. Common pitfalls. Improper registration, delayed registration, ownership, of mark and designs. It's very similar to copyright. Unlicensed use of mark leading to infringement issues. You know, again, you have to go after people. These are things that once you become successful, once you scale up, you really need to get serious about trademarks. You need to start going after infringers, because if you don't go after infringers, there's this argument that you're basically permitting that use. So that's why folks like, for example, Kleenex, you call your box of facial tissues Kleenex and it's not, you know, a Kimberly-Clark product, oh, they're going to remind you that Kleenex is a trademark name. It's only facial tissues from Kimberly-Clark that can be called Kleenex. Everything else is a facial tissue, which if you go look at the boxes, this happened maybe 20 years ago. They're all very carefully saying facial tissues now, because there was a little bit of infringement of their mark, and they started pushing back. And the reason why they're trying to do that is there's something called genericide. You know, when your mark becomes so ubiquitous that it no longer means, you know, facial tissue. It doesn't mean Kimberly-Clark facial tissue. It just means facial tissue. For example, Xerox, go Xerox this for me. Xerox was one of the early companies with a copying machine, and it was subject to genericide. Frisbee was the original Frisbee company, you know, and that became, it lost all value as being a source identifier. It became part of the language. And arguably Google, you know, go Google it, you know, suffered some genericide too. But as long as you keep protecting your marks, again, this is kind of probably not germane to you guys, so sorry I get lost on that, but let's get into trade secret. Trade secret stuff is something you should be concerned about. So why is it a deal? So trade secret, just to kind of give you an idea, it's basically technical know-how, you know, customer list. It's pretty broad. It's state-based law. It's anything that's confidential that the company knows about, that its employees know about. You know, the requirements are that it's kept confidential, so people who are exposed to it have to have non-disclosure agreements. You have to have policies in place to prevent its disclosure. So you just gotta it's basically stuff you don't want outside your company. That's why you gotta make sure you paper up your employees, your subcontractors, make sure you have agreements in place. So examples, you know, Coca-Cola formula, Google search algorithm. What's great about trade secrets is no time limit. As long as Coca-Cola or Dr. Pepper keeps the recipes, you know, protected and trade secreted, they have protection for it. And so, you know, again, now when I say protection, it's only for misappropriation of the trade secret. So misappropriation would be, you know, I'm exposed to the Coca-Cola formula and Pepsi or RC Cola hires me away and I abscond with it, even though I'm under a non-disclosure agreement, and I hand it to them when we start making Coca-Cola ripoffs. They can sue you for misappropriation of a trade secret, which is a lovely cause of action, because again, every state's a little different, and in some states it's criminal. California is one of those states. So you can even have some criminal liability for misappropriation of trade secrets, and you can see why it's criminal there, because of the Silicon Valley companies and entities are extremely powerful in the state capital, and they made sure that, I mean, if you abscond with our technology, there's going to be problems. You know, for example, one of the more famous ones was the Waymo, which is the self-driving unit of Google. Their senior engineer jumped ship and went to, it wasn't Uber at the time, but he formed his own self-driving outfit, and then Uber almost immediately purchased it for like $500 million. And he like walked out the door with like 35 gigabytes of data. Like he downloaded it that morning, sent out his resignation email, and just walked out. And so Google wasn't particularly happy with that, so they sued him for misappropriation of trade secrets. When it ended up shaking out, I think Google got 10% of Uber was kind of part of their settlement. And at a certain point, of course, he was terminated from Uber, you know. But at one point, he ended up taking the Fifth Amendment right to remain silent because there was potential criminal charges down the line, which I think are now being dealt with. So this was just civil. So Google got like a ton of money for that misappropriation. You know, again, you have to be careful. So what I'm saying in your end is like, so if you're hiring people who are like coming from like large corporations who you know they have agreements in place and they have non-competes and non-disclosures, you know, make sure they know their rights and their capability to work for you. So if you're doing like a tech startup, you want to make sure these folks can work in that industry, because non-competes are enforceable in the state of Florida, non-disclosures too. And you want to make sure they can work for you and that they're not going to be infringing any of these contractual obligations. And also, when they come to you, they come to you clean. They can still work on the same stuff, but they can't bring what they did for their former employer into your company. So this is more of a technology thing, more than anything. I mean, yeah, it does apply to like the KFC and Coca-Cola, you know, but in reality, the most of the traction you're seeing is in the tech industry. It's basically, you know, companies are under duress, they implode, someone just walks out with all the technology, tries to start up his own company that doesn't belong to him, that belongs to the company. So you have to be careful about that type of stuff. It's just basically when you're hiring people, you're gonna have friends who are gonna be helping you. Maybe, you know, on their side time, it's kind of a side hustle, right? I'll help you with your startup. Make sure they're not conflicting with any of their obligations with their existing employer. And make sure they clear it, you know, because you wanna make sure everything they create for you, you own, because that's gonna be critical for your startup. Trade secret, common pitfalls, you know, you gotta make sure to pepper up your employees. That just means, you know, employment agreement, non-disclosure, non-compete, everything you can give to them. Get them to sign it. And get them to sign it when you hire them. You know, that's very critical. Unenforceable non-disclosures, depending on the state, those are a state-by-state thing, and lack of security protocol. You can't really call it a trade secret if there's no real protection. So some states require you to have some reasonable measures for security and secrecy. Although you could argue that the Google senior engineer downloading an absurd amount of data onto a drive and walking out is not a very good security. Question?
Right. One of the things that we run in here, because a lot of the students are just exploring potential businesses, so they're talking amongst themselves, they don't have a formal entity set up, not hiring anybody, but they're talking about things that are sort of trade secrets, but no NDAs because they're just in the formation stage. Could you comment on how they should think about that? How many people they should expose to that? What's a process you would recommend?
That's a good question. So you got a cool idea, right? This is a cool idea. You got a cool idea. You think it's got some traction. You start sounding it off some of your colleagues. What do you think about X, Y, and Z? Or a software app that does this, you know, or anything. Whether it's like a business idea, if you're just freely handing it out, you pretty much have no protections. I mean, you know, you got to have some form of non-disclosure agreement in place legally to like prevent them from using your idea. Basically, I mean, if you have a great idea for a business and you tell it to someone else, they can just, without anything else in place, unless there's some type of obligations or duty to you, they can go utilize your idea. Now, realistically, how's that going to happen? Not really. I mean, I think when you're doing stuff like this is part of the community of the startup studios. You kind of want to bounce stuff off. Everyone else has got their own ideas anyways. I mean, realistically, you're not going to be handing out non-disclosure agreements, or you're going to be a very lonely person. You know, you're like, you want to talk to me about my idea, here's the non-disclosure agreement. That may come across as a bit odd. So I just think it's a good idea to sound ideas off, to people you trust. If they're super sensitive, I mean, most people are just talking about ideas broadly, abstractly. You couldn't protect those anyways. Now, once you start implementing the idea, like, here's the code I'm thinking of or utilizing an algorithm, I'd be more careful about that. People you trust, people you can have an informal understanding, again, because things can scale up quite quickly, and well, I helped you with that algorithm, I told you to do this, and that increases efficiency, and it's particularly in software, because things go from like, well, this is just something I'm doing in my dorm room to, oh, every one of my classes is now a member, and we're expanding to different universities, and now VC's telling me to push you out. This is what happened with famously with Facebook. They actually made a movie about it. That's kind of basically how it shook out with Eduardo Severin, is that he was involved early, and then he got pushed out as the company started to take on, sophisticated investors, and it ended up being sold out. I know Eduardo Severin he was so rich, he ended up renouncing his U.S. citizenship and becoming a citizen of Singapore for tax purposes. So he got taken care of. So I think he got his money, and I think the Winklevoss twins were another set of people who were involved early on. So it's difficult because you want to be involved, you want to get these people working for you, you want the smart people like Mark Zuckerberg working for you, but he's not going to sign a non-disclosure with you or non-compete with you, so you kind of have to, take judicious risk but maintain, control of the relationship. It's again, I'm getting off the rails here, but basically, you gotta talk to people, but be careful about what you show them, And also make sure that they're being loyal, like if you're gonna employ anybody, make sure they are employed with you. This is again where you get the non-competes or help. Patents, finally we're getting patents. I promise we'll go through this real quickly. Wait, I got plenty of time, sorry. We're only 40 minutes, I was thinking I started at 1. So, patents, I'm gonna blaze through this so we can get to the question and answer. So there's 3 types of patents. Plant patents, which are relatively rare, and these are effectively for people who are making new hybrids of life. Then there's design, which protects the ornamental characteristics of an article of manufacture. A great example is the original iPhone. There was a design patent on the look and feel of it, and that little button in the middle and the black slab, phone approach. Utility patents, most common, which protect any new and useful process, machine, article of manufacture, composition of matter. Basically, very broad, and those are the most common ones. And there's the provisional patent application, which I'll get to in just a moment. So what exactly is a patent grant? So patent grants are interesting because they're not actually, people would say, I have a patent on this idea, of course I can make it. That's actually not what a patent is. It's a negative right. My negative right is a right to stop other people from making, selling, or using your idea as delineated in the claims of your patent. And why is it, maybe you don't have the right to make it yourself, and that is because if there's a patent that is a base of your technology that another person has, you can't actually make your own invention. So if you need person A's patent to make your invention, let's call it person B's invention, if person A doesn't grant you a license, you can't actually make your invention. But person A also can't make your invention because it's a negative right. They have the right to prevent you from making their invention. You have the right to prevent them from making your invention. So you would have to actually if you wanted to collaborate, you'd have to cross-license. So again, this is not a license to make your own invention. Must go to federal court to enforce it. So patent term is 20 years from the earliest priority date, which is your filing date, and design is 14 years from your grant date. If you write the price, right? Yeah, so patents are a little different. So there's no common law. There's no like with trademarks, well, you can just kind of fix it later on. Same thing with copyrights. And even trade secrets, as long as you keep it confidential. I mean, you don't really have to do anything with trade secrets. But you need to file a patent application to get patent rights. And again, if you don't, there are issues. And the issue being is that disclosures can affect your patent rights. So the second you commercialize your invention, it starts the clock. Whether it's putting it out on the web, whether it's putting it on an app store, any type of commercial deployment, you got 1 year to file that patent application. You don't file it, you've basically foregone patent protection. So it's the only thing I've talked about where if you don't do something, you lose it. So, and again, you gotta file something, even if it's a provisional application, which I'll get to, I think in a second. I'm pretty certain there's another slide coming for that. But, so again, patents are just like copyrights. They're effectively, copyrights is bread and butter for content creators like Fox, Disney and such, Universal, Sony. Patents are the assets of choice for technology companies. You go look at Apple, IBM, Google, they're filing thousands of these things. They're territorial in nature, so U.S. patents only for the United States. Foreign patents are for each and every country. They're only effective in the country that patent's granted. They're transferable. You can monetize your company, and again, they're great for permitting you to kind of get raises. Sometimes if you're a startup, why should I spend money? If you're a technology startup, why should I spend money on patents? Patent attorney's not inexpensive. I understand, but it allows you to sometimes do raises because investors show up and they're like, well, this is a great idea. I can give you $50,000, and I'll value your company at X. Well, we have to stop someone else from copying your great idea. A patent is a way to prevent other people from basically encroaching on your idea. So it allows you some exclusivity, and investors love that because it means there's going to be a period of 20 years where we get to just basically own the market. Again, offensive use, they can be used in court, source of licensing revenue, and I think that might be it. Oh, yeah, patent, here you go, the disclosure in all forms. So, yeah, don't disclose. Actual disclosure means like putting it out on the web. Offers for sale or a license, even confidential ones, even if you have a non-disclosure in place and you're talking to an investor, you're selling your idea, that counts as disclosure. You got 1 year to file that patent application. Public use without experimentation. So there's a thought process out there, like if you got a mechanical device, let's say it's a construction device. I had a client with a construction device, and he was using it out on the site. So technically the 1 year starts to roll. Unless you're doing it for experimentation. If you're changing the idea, you're kind of figuring out how it works, there's an exception to public use, which is you can utilize in that instance, but it's very limited. Pro se filings. A pro se filing is better than no filing at all, particularly if you're disclosing it, but I would recommend you hire an attorney. But there are things you can do, to protect your rights. Pro se is better than nothing, I would go with. All right, brace yourself. So before I get to this, though, we go back one. Before we get to Ned, let's talk about the provisional application. So there's a utility application. The provisional application is basically kind of a stopgap. You file it, it gives you a filing date, it protects your rights, it gives you 1 year to convert it. If funds are low, do the provisional, because it's a lower filing fee, the $140 versus $860. It has no formal requirements, and it's easier to file as a pro se applicant. And then you can hire an attorney when you go convert it. And it's better to do that than go forward with it. So if you got a tech startup, you don't have the money for a patent attorney, consider a provisional application. And feel free to reach out to me, by the way. But if you have any questions, like I've ended up talking to a couple people since the last time I did this lecture. Feel free to reach out to me. I'm happy to give you, any advice to help you in your company in the early stages. And just if you ever have any questions, don't hesitate to reach out. But even if you're going to do a pro se, at least reach out to an attorney to get some instruction, because it's better than going on your own. So I think I did a good job.